Floor today to discuss the Congressional Review Act resolution that Senator McConnell, the Republican leader, Senator Enzi, the senator from Wyoming, and I have filed to stop a new National Labor Relations Board rule. Last December, the National Labor Relations Board issued a final rule that shortened the time between when pro-union organizers ask an employer for a secret ballot election and when that election actually takes place. I refer to this as the ambush election rule because it forces a union election before an employer has the time to figure out what's going on. Even worse, it jeopardizes employees' privacy by requiring employers to turn over employees' personal information, including email addresses, phone numbers, shift hours, and locations to union organizers. Mr. President, this action of the Labor Relations Board, which increasingly has become a union advocate instead of an umpire of disputes between employees and employers, it's attracted enormous attention across this country. I have letters from the United States Chamber of Commerce, from the Coalition for a Democratic Workplace, from the National Council of Chain Restaurants, from the National Retail Federation, the Retail Industry Leaders Association, the Associated Builders and Contractors Incorporated, the American Lodging and Hotel Association, the HR Policy Association, the National Association of Manufacturers, the Society for Human Resource Management, the Associated General Contractors of America, 173 total organizations, Mr. President, who have registered their deep concern about the unfairness of this ambush election rule. And in the time that I have today and that others, I see Senator Enzi is already on the floor. He has for many years fought this battle. We want the American people to understand why the ambush election rule is such a bad idea, why it's so unfair to employers by causing them to be forced to have a union election before they can figure out what's going on. And for the same reason, it's unfair to employees. They have to vote in a union election before they have a chance to hear both sides. Here's how the procedure will work. If a majority in the Senate approves this resolution, it will then go to the House for a vote. If it passes both houses, the President can veto the resolution. It would take 67 votes in the Senate to override that veto. If the NLRB's new rule is disapproved, the board can't issue a substantially similar rule without congressional approval. Mr. President, the question I would ask is, what's the rush? What's the problem here? Today, more than 95% of union elections occur within 56 days of the petition filing. 95% within 56 days of the time a petition is filed. But under this new rule, elections could take place in as few as 11 days. This rule will harm employers and employees alike. If you're an employer who gets ambushed in that 11-day quickie election, here's how it works. On day one, you get a fax copy of an election petition that's been filed at your local NLRB regional office stating that 30% of your employees support a union. The union may have already been quietly trying to organize for months without your knowledge. Your employees have only been able to hear the union's point of view. By day 2 or 3, you must publicly post an election notice in your workplace. And if you communicate to your employees electronically, you have to publish the notice online as well. By noon on day 7, you must file with the National Labor Relations Board what is called a statement of position. This is a comprehensive document in which an employer sets out legal positions and claims in writing. Under the NLRB's new rule, you waive your rights to use any legal argument not raised in this document. So it should be pretty obvious, Mr. President, that by day 7 at least, you will have to have a lawyer on hand at least for several days before that. You probably need that lawyer on hand on day 2, hopefully on day 1, because if you make any mistake, in these filings, you might have in the lead up to the election, the NLRB might set aside the results and order a rerun election, or worse, when a bigger mistake is made, could require an employer automatically to bargain with the union. Now think about the real world, Mr. President. At our hearing before the Health, Education, Labor, and Pensions Committee, a representative of the National Federation of Independent Businesses testified. She said there are 350,000 members of the NFIB. That's just some of the small businesses in America. The average number of employees that organization has is about 10, as I recall. So you've got small businesses all over America. They don't sit around with labor lawyers. They don't have money to hire labor lawyers. And they're expected to know within a day or 2 exactly what to do about a complicated petition before the NLRB because of this ambush election that could cause the election to happen within 11 days. On day 7, you must also present the union and the NLRB with a list of prospective voters, as well as their job classifications, their shifts, their work locations. Now, if you're a business with 5, 6, 7, 8 employees, seems to me like you're going to be spending your whole time working on this union matter in a compressed period of time. Your customers might be wanting your services. They might wanting deliveries on whatever it is you make. They might want on-time deliveries. All of a sudden, you're running around trying to find a labor lawyer, trying to avoid making mistakes so you can deal with this ambush that suddenly comes. On day 8, a pre-election hearing is held at the NLRB regional office, and an election day is set on day 8. By day 10, the employer must present the union with a list of employee names, employee personal email addresses, employee personal cell phone numbers, and home addresses of employees. You've got to hand that over to the union organizers, whether the employees want that or not. Day 11 is the earliest day on which the NLRB could conduct the election under the new rule. Under the new rule, the union has the power to postpone an election by additional 10 days at this point, but the employer has no corresponding power. So you have the ambush. The ambusher, the union, has the power to postpone the election that it is forced to be called. But the employer, who's been ambushed, has no similar right. So under this new NLRB rule, before the hearing on day 8, an employer will have less than 1 week to do the following things: figure out what an election petition is, and for most of those hundreds of thousands of small businesses with 5, 6, 8 employees, they might have no idea what it is. Find legal representation. Not only find a lawyer, that's not just a matter of looking in a phone book, it's a matter of finding a lawyer with whom you'd be comfortable, who you would trust, who you know has some ability. That would take a while, particularly if you're not a great big company and you're not accustomed to labor relations litigation. Determine legal positions on the relevant issues. Learn what statements and actions the law permits and prohibits. These are all things that on day 8, an employer will have had to do. Communicate with employees about the decision they are making. Correct any misstatements and falsehoods that employees may be hearing from union organizers. And as I mentioned earlier, making even the slightest mistake in the lead up to an election can result in the NLRB setting aside the results and ordering a rerun election. Or worse, when a bigger mistake is made, the board could require an employer to automatically bargain with the union. But, Mr. President, it is the employees who stand to lose the most under the new rule. In the first place, all of the employees, some of the employees may know what's going on before the union files its notice of an election, but all of the employees don't have a chance to hear both sides of the issue in an ambush election. Second, because of the ambush, that's the first, they may have only heard half the story. Only 4.3% of union elections occur more than 56 days after the petition filing. I mentioned this a little bit earlier. And the current median number of days between a filing and an election is just 38 days. These figures are well within the NLRB's own goals for timely elections. The unions won 64% of elections in 2013. In recent years, the union win rate has actually been going up. So what's the rush? Why is 38 days, the median number of days between a filing and an election, why is 38 days too long? It's well within the NLRB's own goals. The NLRB is winning more elections than it uses. And then let's go to the 1959 debate, when we can look to a former member of this body, Senator John F. Kennedy, in a debate over amendments to the National Labor Relations Act. He warned against rushing employees into election. And this is what he said: there should be at least a 30-day interval between the request for an election and the holding of the election in which both parties can present their viewpoints. Senator John F. Kennedy, April 21st, 1959. If Senator Kennedy thought 30 days was approximately right, if 38 days is the mean of what's happened today, if that's within the NLRB's own goals, why the rush? Why the push for an ambush election? Why have an election that can be set in 11 days before employers and employees know what's going on? Mr. President, I might add this. When a workplace is unionized, especially in a state that has no right to work law, employees have dues money taken out of every paycheck, whether they like it or not. They lose the ability to deal directly with their employer to address concerns or ask for a promotion or a raise. Instead, they have to work through the union. Important considerations like which of their employees will be included in the bargaining unit will be no longer determined before the election. As the two dissenting members of the NLRB put it when this rule was decided, employees will be asked to, quote, vote now, understand later. And I would like to emphasize what the employees are losing, rather in addition to the opportunity to fully understand the election before them. They're losing their privacy, Mr. President, because the rule requires employers to hand over employees' personal email addresses, cell phone numbers, shift hours and locations, job classifications, even if the employee has made clear he or she doesn't want to be contacted by union organizers. Now, some on the other side say, well, it's the modern age. We have the internet. We have Google. Let's get modern. I would think because we're in the modern age and privacy is assaulted so much on every side, we'd be even more careful about not just rushing up an election, but saying to the employees who may not have any interest at all in creating a union that just because a petition is filed by 30% of the employees, that within 11 days, employers have to hand over your personal email address, your cell phone number, your shift hour and location, your job classification, even if you don't want that to happen. Even you don't want that to happen. This rule appears to be a solution in search of a problem. It is clear to see that it's wrong, and that is why Senator Enzi, Senator McConnell, and I are asking the Senate to disapprove it today and prohibit the NLRB from issuing any similar rule. I'll come back on the floor, Mr. President, during our debate time and talk about how this is one part of a process by the current National Labor Relations Board to become even more of an advocate than an umpire. That is the reason that Senator McConnell and I have introduced legislation that would change the National Relations Board back from an advocate to an umpire by doing three things. One is end the partisan advocacy by creating a 6-member board of 3 Republicans and 3 Democrats and a majority will require both sides to find a middle ground. Second, rein in the general counsel. Businesses and unions would be able to challenge complaints filed by the general counsel in federal district court. Number three, encourage timely decisions in two ways. First, either party in a case before the board may appeal to the Federal Court of Appeals if the board fails to reach a decision in their case within 1 year. This rule, this ambush election rule, is part of a general trend that has caused the NLRB to shift dramatically toward union advocacy. And when I come back on the floor, I'll also talk about the joint employer standard and the consideration the NLRB is giving to a decision that would destroy more than 700,000 American businesses called franchises. These are the men and women who operate health clubs, barbershops, auto parts shops, child care centers, neighborhood restaurants, music stores, cleaning services, much more. You combine the attack on franchises with the ambush election rule and the case a couple of years ago about micro-unions so that unions may target even a small unit in a large company. And you see that there's a consistent trend here, an effort by unions and their friends in the NLRB to tip the balance in a way that it was never intended by the creators of the National Labor Relations Act. The National Labor Relations Board is supposed to be an umpire, not an advocate. And if there ever was an example of unfairness and tipping the balance in one direction instead of the other, it would be an ambush elections rule, which allows a union organizers to, within 11 days, ambush a company unsuspecting, force an election before the employer and all of the employees have a sufficient amount of time to figure out what is going on. And in conclusion, I would think that Senator Kennedy's advice would be good advice to follow. A lot has changed since 1959, but fairness hasn't changed, balance hasn't changed, giving everyone a chance to have an opportunity to know what is going on hasn't changed. There's nothing different today than there was then about that. Senator Kennedy thought 30 days was about right. 38 days is the mean today. This ambush election rule would reduce it to 11. That's the wrong thing to do, Mr. President. I hope the majority in the Senate agrees with me on that. I hope the House agrees with us on that. I hope the President will agree with us on that. And if he vetoes it, as he has said today he might, then I hope a majority of both parties will speak up for employers and employees in the United States of America and say no ambush election for us. Thank you, Mr. President. I yield the floor.